Hello, everybody. You guys are all so efficient in signing on early. Thought there'd be nobody here yet. Hi, Anastasia.
Hi, Joy. How are you?
Good. How are you?
Good. Nice to see you.
Too. And thanks for doing this.
Oh, I'm looking forward to it.
Good. Good. So do you want me to, when we get started, I'll turn the presenter over to you. You have slides?
Yeah, I do.
Okay. Okay, perfect. Excellent. I brought a little present for everybody. I thought that'd be a little.
Sweet.
Oh my God.
Thank
Just
you.
those little faces.
Look at those. Oh, you know your audience.
Yeah, I do. I do. They're going to Reno tomorrow.
That's my hometown.
Oh, really?
Yeah.
We do a lot of transfers and working with the shelters up there. So we just took up, I think, 35 bottle babies, like neonate kittens on Tuesday. And tomorrow I'm taking up, I have no idea how many, probably at least 20 or 25 kittens and moms and adult cats. And
wow.
these little guys are staying in the house tonight because they're little.
They are too cute.
Aren't they adorable? You know your little stars?
Oh,
Your little stars? Yeah.
oh, they're so sweet. I love it.
It is raining kittens right now.
It is that season, I guess.
Yes, it is. Yep. Did I wake you guys up?
How rude.
Yeah. Yeah. Uh-oh. What? What do you think, huh?
Is that your new fur stole?
Yeah, I have my little fur starter here. Keep my neck warm. Yeah. Look at they got sharp little claws though.
Oh yeah.
They do. So Emma, when's your surgery?
27.
Oh, okay. So we get you for another month. Emma's having a hip replacement.
Oh my gosh.
Did I wake you up? I'm sorry.
It'll be good when it's all done.
Yeah.
Oh.
I might have to nip your claws. Look at the fat belly on this one.
Oh my God.
He doesn't like you doing that.
Yeah. It's like, what? You're teasing me.
Oh my gosh. There it is.
What you think, huh? So where did you grow up in Reno, Anastasia?
Actually, kind of in the old Northwest, like right around UNR.
Okay.
Yeah. Went to UNR for college and then moved to Sacramento to go to law school at McGeorge and stayed.
And you liked it here, so you decided to stay.
Yes, it doesn't snow, and that was a big
Yes.
this temperate climate. I actually well in February I took the Nevada bar. So
so you can you can practice in both states then.
Yeah. There's some different stuff we can do with trusts and all that in Nevada that we can't do here. So
oh really?
Yeah, they have a lot I guess I want to say like looser rules for like asset protection trusts, and you can do all kinds of fun stuff with them.
Oh, okay.
Yeah. So I'm waiting for the results on that.
So then you'll be able to go back and help all your family and friends there.
Yeah.
So do you have any cats?
I do.
How many do you have?
I have one right now. Her name is Elsa.
Oh, that's great.
And I've got several pictures of her throughout this.
Oh, good. Oh, good.
I've got. And I've got, yeah, there's all kinds. Yeah, she's I've always been a cat person ever since I was little. And yeah, she's my baby right now.
Me too. I guess I kind of like cats.
I guess.
Yeah. Look at that one, Cindy. Oh, how handsome.
Oh.
You're on mute.
There we go.
There we go.
There you are.
His name is Zampino.
Oh,
That-
You know, I love it.
That's paw in Italian.
I
Oh,
love it.
he is handsome.
Yes,
He's
he
very
is.
handsome. He's a sweet boy.
He kind of looks like, wait a minute, wait for it. Wait for it. This one. He's like a midget of this one.
Oh.
It's a midget of them. Yeah.
Oh,
Yeah.
Weeks.
We're working with a lot of shelters up in the North State area that just have no resources. And they're just kittens are just, coming out of everywhere.
Oh, gosh.
So we're bringing a lot of kittens down from there. And then we are kind of holding off on our resources because we have Silicon Valley. They come and they'll take 40 or 50 from us at a time.
Wow.
And so we're taking advantage of that. And of course, in Reno, the weather so far is, kittens are, I'm sure there's being born, but not like they are here because it's just now getting, the weather's getting better. As long as they'll keep taking kittens and cats, we'll keep transferring and sort of keep our resources for then when that gets filled up, and then we'll start.
Right.
So we really don't have in Placer County, because we've been here for so long and so many other great organizations in Placer County, we don't have a kitty overpopulation problem here. So most of our cats come from out of county.
Interesting.
Yes. Yeah,
And
so
from more like private sources, just people who find
It's-
them, or
it's a lot of shelters. We
Shelters.
try and work with shelters and rescues that are up in those areas. And they just don't have, there's not the spay neuter resources up there. And some of them are culturally not as developed, is a nice way of putting it, I guess, as we are here. And they just don't have the same philosophy. We'll get them there. I mean, they'll get there at some point. And they're still doing a lot of killing. I mean, to be honest with you, they are. And I'm working with Best Friends. I'm not sure if you've ever heard of them. They're a big national organization. So I'm working with them and Alley Cat Allies to just sort of implement some change
That's
around
awesome.
the area. And we're always coming up with, new programs to try and help those. And actually Reg Murray he's one of the on here. He is a volunteer who does all our grant writing. So
Wonderful.
he is, we're actually working on a couple right now and getting creative ways to try and get as much grant funding as we can for these special projects. And we're bringing cats from as far north as Shasta County down to this
Wow.
area, and then shipping them off to different places. And so we got lots of people jumping on now. The magic moment here. We had, I think, 30 or 31 signed up.
Wow.
So
It took me a few minutes to be able to log in. I don't know why it wasn't connecting.
oh, okay. Well, we'll wait a couple more minutes then. And if you hear, I don't know if you can hear all the geese out from, the geese are, the Canadian geese are flying here.
Love it.
They're crazy. They always seem to be, when I get on a Zoom, they like to just start making
Well,
lots of noise. So last year, speaking of, trusts and that type of thing, last year, one of our longtime rescuers in the area passed away, and she left most of her estate to us, and she had, it was pretty significant.
Wonderful.
So that was it was so great. I mean, not great to get that, but I mean, it really is allowing us, and she wanted her funds to be used for spay neuter. So so we're able to, there's a big, huge colony in Yuba City right now that we're working on, that there's no funding up there, and there's probably about 60 cats. And so we're now using some of those funds to work that colony.
Yeah.
And, so it's estate planning is really a big thing, and important to us as an organization.
Absolutely. Yeah.
So,
that's a great source of funding and a really good way for people to be able to be charitably minded without necessarily having to give a lot, while they're alive, or reduce their, daily living expenses or something.
That's what I'm hoping to do.
Right? Same. Yeah. And so, we can preserve. And so we're going to talk a little bit about just some general estate planning. We're also going to talk about planning for the pets. And then we're going to talk a little bit about charitable giving. So we're going to do quite a gambit today.
Okay, good. Do you want to go ahead and I could do one more. Let me do one more flash. Okay.
Yeah, I'm good. We can hang out for a little bit if we want to wait for people, or whatever you guys want to do.
For those of you that just joined,
you are working with our family. My sister and I both have had our trust done with you. Donna?
Yeah.
Oh, cool.
Yeah.
What a small world.
I know, right? I know your name. I don't think I met you.
No, well, it's nice to meet you.
Yeah, nice to meet you too. But I know of you guys, and I have my trust, but it hasn't been updated since 2014.
Yeah, we might want to take a look.
Yeah, lots have changed since then.
Isn't that the stuff? It just kind of sneaks up on you, and you look back and go, wow.
Yep.
Well, you can do that anytime. Most, anything, I'd say probably 95% of anything that you're going to need to update is going to be covered by that routine amendment. So. Right.
I just haven't.
Yeah.
I did it when I was diagnosed with cancer, because I was pretty sure I was going to die, and I didn't.
Yay!
Yay! We're proud of that.
Round of applause for that.
Yes, thank you. Yeah, but I never went back and updated it when I've got new cats now and everything has changed. So.
Yeah. Well, anytime, we're here. You know where to find us.
I do know exactly where to find you. I'll call you guys. I wanted to hear this.
Yeah,
to see
sure.
how I'm going to change some things too.
Absolutely. And this is kind of we're going to cover a lot of information. So some of the ideas that we talk about today might work, but there's probably others, as well.
Right.
Well, I'm going to go ahead and let's see, give you, you should be able to have sharing right now, Anastasia. See if you can.
No, it says host disabled participant screen sharing.
One participant, multiple advanced sharing. Oh, there we go. I knew I was in the wrong place. Okay, now try.
All right, let's give that a shot. Oh, yep, there it goes.
Okay, yay.
Okay, should I go ahead and get started?
I think so. I haven't had anybody join. We've got 12 people
about
on.
half.
So I haven't had anybody new join on in about 3 minutes, I think. So.
Okay. And I think we're recording it. So
yes.
Obviously we can send this out to anybody who wasn't able to make it. Okay, so let me, well, very quickly while you guys can all still see my face. Hello, I'm Anastasia Salmon, attorney with Drobny Law Offices, and I'm here. Thank you very much for giving me your time for the next hour or so. And I'm just going to take you through an overview of some general estate planning, some planning on behalf of the pets, and then a brief overview of some charitable gifting techniques. Okay, let me get this guy all queued up. Bear with me. That is not what I wanted to do. There we go. And slideshow. Okay, can you guys all see that? Is my screen sharing? Okay. This is Elsa. This is my lovely little kitty. All right, so let's just go on and dive right in. So some of you probably, even if you don't have a will or a trust or anything like that, you've probably done what we call some informal planning. So one way that you will see this is when people own property as joint tenants. Joint tenancy comes with a right of survivorship. So when one joint tenant dies, the remaining joint tenant kind of absorbs their interest. It's very easy to take the decedent off of title. You just record this affidavit of death of joint tenant. And so that is one way that people kind of do an informal process for ensuring that their property passes to whom they want it to when they die. Similarly, you'll sometimes see parents add their children on as joint tenants. Ultimately, what happens is, you know, one spouse dies, then the other four just kind of come up again. Second spouse dies and the three children now own the trust. Now, these kinds of ownerships come with, their own kind of risks. With a joint tenancy, when you gift the property, when you add your kids to title, you're actually giving them an interest in your house. So in this scenario, each of these kids owns a 20% interest in this house. Under the law, any one of these children can go and try to sell their 20% interest or gift it to somebody else. And they do not need the permission of anybody else, any of the other joint tenants. So while it's like, yes, ultimately the property will end up where we want it to be, there's some concerns that we have during the lifetime. It doesn't really plan for making sure that that property is available for you during your lifetime. Some other informal methods of estate planning are the beneficiary designations that you probably all have in one way or another. These are on your retirement accounts, your annuities, your life insurance, your pensions. And again, so the beneficiary designation means that you've nominated one or more people or entities to receive the assets of that account upon your death. There usually isn't much of a problem with that, right? It just passes right to them. There can be an issue raised where your beneficiary predeceases you, because then it's going to end up in their probate estate. It does not just automatically go to their children or their spouse. You also run the risk of having your beneficiary not being able to accept assets. So for our purposes today, if we wanted to set money aside for the benefit of a pet, we cannot name the pet as the beneficiary of our retirement account. That will not work. It will ultimately end up going through your probate estate, which we're going to talk about a little bit later. So you also run the risk of, for some reason, the beneficiary not being able to accept property because of public benefits. Maybe they're on Medi-Cal because they're disabled, right, at that point. If they then receive a bunch of money, they're going to get kicked off their public benefits. So often what we do is when we have a client who has created a trust, which again, we're going to talk about in a little bit, we can name the trust as the beneficiary of these accounts. We can then designate in the trust, my IRA will go to Sally, And in that instance, if Sally is disabled at that point, the trust can hold the money for her benefit. And we've kind of gotten her the money, but also avoided messing with her public benefits. That applies to minors as well. If we want to name minors as beneficiaries, it's really not going to work because they can't accept property on their own behalf. And you end up having to establish a court supervised guardianship to receive those funds. So planning does, you want to be thinking about who your beneficiaries are and what their position is, what their circumstances are. Other parts, so we do take into consideration taxes when we talk about estate planning. These are all not even all, but most of the big types of taxes that we take into consideration. We're not going to talk about all of these today, as I'm just going to hit probably the two biggest ones when we talk about estate planning. So the first is capital gains. So a capital gains tax is a tax on the profit that you've made on an asset. When you purchase a property, the purchase price becomes your tax basis. Your gain on that is anything above your tax basis. So here we purchased the property for $20,000, and right now we're going to sell it and it's worth $100,000. So we have a $100,000 gain. We have an adjusted basis of $20,000, which is what we paid for it, which means we have a taxable gain of $80,000. So we would be paying roughly 40% of the $80,000 to the IRS. When you gift or transfer property during your lifetime, it will apply what's called the carryover basis. And what that means is that whatever my basis is in a property, if I give it to Joy, she then takes my tax basis. So the tax basis carries over to the recipient. So we get the question a lot of, well, why can't I just give my house to my son right now? I want him to have it eventually. I don't think he's going to kick me out. Again, I would probably counsel against that because you never know. But one of the disadvantages of that is that your son then would carry over your tax basis. And if he then sells the property, he has that $80,000 capital gain liability. But when an asset is included in your estate at your death, you receive a step up in the basis as of the date of death. And the way that works is we take the value of the date of death, which evidence of sale is usually pretty good for that. So if I've now died, my son's inheriting the property and it's worth $100,000 on the day I died. Our adjusted basis is now $100,000 because I got that step up. And so my son has zero capital gains when he sells the property after he inherits it from me. So if we want a real estate or stocks are the appreciated assets that we're really looking at for this. So instead of doing a lifetime gift, just because you want that person to have it, at some point or after your death, you're not necessarily giving them the full benefit that you could be if you did it through estate planning with a trust or some other type of vehicle that's going to allow you to get that step up in basis at the time of your death. With the joint tenancy that we were talking about a little bit earlier, when one joint tenant dies, because each joint tenant really owns one half of that house in this scenario, we only get a step up in the basis on the half that's owned by the spouse that has died. So now if we sell the property, we've somewhat reduced our capital gains, but the surviving spouse, when they sell, is going to have a capital gain of $40,000. So we'll be looking at about $16,000 in capital gains to pay on that. So again, one more reason why it's good to not use these types of informal planning devices is that if we put it into a trust, if I'm married, when the first spouse dies, we get a step up in the basis. Then when the second spouse dies, we get another step up in the basis. And so you've really given your beneficiaries the benefit of basically just reducing capital gains up until the point that you are dead. And it's going to save a huge amount of money. We're going to talk about the estate tax a little bit later, but kind of in the realm of planning, and informal planning is also planning for disability, right? We don't want to just plan for where does everything go when I die. We also want to plan for what happens if I am not able to manage my own resources. What happens when I have dementia and I can't pay my own bills or conduct business on my own behalf? For financial decisions, if we don't have anything in place and I lose capacity, generally what we're looking at is a conservatorship of the estate. You may have heard this term, conservatorship. It's basically like an adult guardianship. A person is appointed by the probate court to oversee the conservatee's assets. That is a court supervised administration. They have to file annual accountings with the court. There's a lot of oversight on these. And because of the court's involvement, it's expensive and time consuming. Similarly, if we don't have anything in place and we become incapacitated to the point where we can't make our own healthcare decisions, we are going to be looking at the court appointing a conservator of our person. And this person then is charged with our physical well-being. Again, it's a court proceeding. So establishment of a conservatorship that is not contested will generally run somewhere between $5,000 and $6,000 just to get it established. And then there's ongoing fees as to, the accountings and further court hearings and things like that. The way we can avoid this is to, again, just have our proper planning. So durable powers of attorney for finance and healthcare decisions can negate the need for a conservatorship, because what you're doing in these documents is saying, if I become incapacitated, I appoint this person to act on my behalf, and I'm giving them all of the powers that I've enumerated in this document. And so all of the powers that a court would be able to give them, you've already given them. And establishing a revocable trust can often do the same thing. What you do when again, we're going to talk about this in a little bit more detail, but assets are funded into the name of the trust. The trustee holds title to those. If it's my trust and I'm the trustee and I become incapacitated, my trust already includes a nomination of a successor or alternate trustee who can then just step right into that position and manage all of those assets on my behalf, pursuant to the terms of the trust. So usually those three documents will pretty much cover any authority that somebody would need to act on your behalf in the event that you become disabled. Okay, so in California, when someone dies, either without any estate planning documents like a will or a trust, or if they just have a will, their estate will need to go through the probate process. The probate process is just a court overseen administration of an estate. So these kind of bullet points are all the steps that need to be taken throughout the whole probate process. So we find the original wills, We have to file a petition to enter the will into probate, or a petition to have somebody appointed over an estate that doesn't have a will. We have to publish notice to the general public, actually, in a newspaper. We have to file an inventory of all assets of the estate, which is public record. We pay the debt, do an accounting, submit to the court a plan for distribution. We have to wait for the court to authorize us to make distribution pursuant to the will or the statute. Then we file the receipts once we've done that, and the court discharges us and closes the estate. That whole process will generally take about 1.5 years, given all the time that it takes to prepare all the pleadings and wait for your hearing dates and things like that. There is zero privacy in probate. Everything is public record. I can go into the probate court and request copies of documents and, financial records, who got what the accounting was, how much they got in compensation for any estate that's been filed for the last 50 years. So there's really no privacy with the probate process. And generally, the way that we get around the probate process is with a revocable trust. That whole, the court oversight, the filings with the court, all of that is not needed to administer a revocable trust. Probate fees are pretty high. The problem here is that the probate fees are based on the gross value of the estate, not the net value. So let's say I die and my only asset is a house that's worth $1 million, but I've got a mortgage on it for $999,999. We would think, well, I really only have $1. The probate court says, nope, your estate is worth $1 million, and we're going to calculate the fees that it has to pay on that number. And so this is the statutory scheme for how they calculate those fees. So just for an example, for a $500,000 estate, you're looking at a total attorney and executor fee of $26,000. I can tell you that to administer a trust with, assets about that value would generally cost maybe a few $1,000s. So probate is incredibly expensive because of this statutory scheme and just the way it ends up working. So to get out of probate, best way to do it is a living trust or a revocable trust. We call it a living trust because you make it while you're alive. We call it a revocable trust because it's revocable. You can change it, you can revoke it. It's not set in stone. So the basic structure of a general living trust is we have the trustor, who is, let's say, me, and I'm going to be putting my property into this trust. Oops, wrong way. Okay, so I am going to nominate myself as the trustee of this trust, and I am going to retitle my property in my name as trustee. My trustee, who is then me, administers the trust for the benefit of the beneficiaries. In most cases, while I'm alive, I'm the beneficiary of the trust. This is all, designed to ensure that your money is there when you need it. And then after you don't need it anymore, then it goes to who we want it to. The threshold for probate, just so you guys know and have this in your head, if your property is valued under $166,250, you can avoid probate even without a trust. Really what we use this number for is we may not fund or transfer title of your everyday checking and savings accounts to the name of the trust or to your name as trustee. Because you have to get new checks and then you have to sign everything as trustee, and that's a pain. So what we can do is we can fund your big assets into the trust, and we can leave those little operational accounts. And at the end, after you're gone, as long as that is under that 166, 250, we can grab those assets and bring them into the trust after you're gone. So it makes the day-to-day operations a little bit easier. So again, the trust needs to be funded. An empty trust doesn't do much. The trust terms only apply to property that is held in the name of the trust. So it would be Anastasia Salmon as trustee of the Salmon Trust. The trust is going to be revocable, so you can amend it at any time, which means you can change your successor trustees, you can change your distribution provisions, you can change the powers of the trustee. You retain full control over everything during your lifetime, even though you're putting it into this trust. So it's not like a Medi-Cal planning trust, or you might hear of like an irrevocable trust or an asset protection trust, where when you give property to that trust, you lose control over it. We're not doing that here. We're retaining control. So even if I put my house into my revocable trust, I can go and sell it tomorrow. I can go and get another mortgage on it. I can refi it. I can buy new property, whatever I want. Nothing changes with how, I deal with my own assets. We can add co-trustees. So when you're thinking about who would I want to take over for me if I was unable to manage this for myself or after I'm gone, you can name more than one person. I do recommend that you think very carefully about how those people are going to work together, because there can be some friction if you've got two co-trustees that don't like each other. So some things that you're going to want to think about when you're dealing with establishing a trust. One is the funding. First off, who is responsible for doing the paperwork to get your assets into the trust? Is your estate planning attorney going to do that? Or are they going to say, here's your trust, now go fund it? In our case, we handle all of the funding for our clients. So we will prepare the deed to transfer your house into the trust. We will do your beneficiary designation forms as much as we can, unless you have to go into the bank in person and do it, we will do it for you. And we do not charge any extra fee for that work. An annual review is actually really important. So you want, when you're thinking about hiring an attorney to do a trust or to do some estate planning, you have to think about it as a service, not a product. So while yes, I am going to give you a finished product of a suite of documents, that, your need for counsel regarding those documents is going to continue, right? That document is going to need to change as your life changes. So an annual review, if that's included in your package price, is going to be a really good benefit to you. In our firm, once we have you listed as a client, we send you a letter every year to kind of tickle you to, Nancy's shaking her head, to kind of remind you like, hey, did anybody die? Was anybody born? Did you get married? Did you get divorced? Did you buy new property? Kind of trigger you to think about things that may require updates to your estate planning. Routine amendments go along with that review. So when we review it, if we find that we do need to make some updates, is my attorney going to charge me to do those updates, right? Is this going to be something that I'm going to have to spend a couple $100s on every year? Most attorneys do charge like an hourly rate or an additional flat rate to do further work or amendments on your estate planning documents. As part of our package, we include routine amendments to any of your documents for the rest of your life. So if you need to change your trustees, or you need to change your distributions, or you've got a new cat that we need to add to the trust, or we need to make sure that FieldHaven is getting a bigger share, all of that is going to be a routine amendment that you will not be charged for. And that doesn't matter whether it's 6 months after you do your trust or 10 years. The last thing that you probably want to think about is ongoing funding. So again, we've got a trust, we've funded it. 5 years down the road, I go and buy a vacation home in Tahoe. I need to put that property into my trust. We will do that for you at no charge, again, for the rest of your life. So any ongoing funding, whether that be updating beneficiaries, or you got a new investment account that we need to add to the trust, anything like that, we will take care of the paperwork for you at no additional charge. Okay, little bit of fun tax stuff. This is the last boring tax thing. So the federal estate tax, California does not have an estate tax. So when I'm talking about the estate tax, I'm only talking about federal. Right now, the amount that a person can pass after their death to anybody is $11.7 million without taxes. It's nuts. So really, 90% of people, you don't need to worry too much about the estate tax right now. However, President Biden has put a suggestion forward to lower this to $3.5 million per person. We don't know what's going to come of that yet. We will have to see. So basically right now, anything, if I die and my estate is worth $12 million, I'm going to pay a tax on the amount that's over the 11.7. So I'm just going to pay a tax on that $300,000. But how can we avoid the tax if we think it's going to be an issue? First, anything that you give to your spouse is going to be free of tax. You have an unlimited marital deduction. Then we have this unified credit, the exemption equivalent, which is that $11.7 million. So this is kind of a historical look. As you can see, it jumped up really high in 2018. It went from about 5.5 to about 11.2. So right now, again, the tax is a 40% tax for amounts over $11.7 million. Portability is going to be a great way for us to avoid taxes, the federal estate tax, if that exemption amount is lowered in the future. And what portability is it allows a surviving spouse to add their deceased spouse's unused exemption amount to their exemption amount. So let's say I'm married and my spouse dies in 2021. All of the property is passing to me. So my spouse has not used any of that $11.7 million because of the unlimited marital deduction. What I can do is file an estate tax return timely, and I can basically tell the IRS, I'm going to use this $11.7 million. So I do that, and let's say that I die in 2026. And let's say that the estate tax exemption by that time has gone back down to $3.5 million. When I die in 2026, I get my 3.5 million exemption plus the 11.7 million. So I'm now looking at a $15.2 million exemption. So if there hasn't been, a lot of appreciation in your estate, using the portability right now with this crazy high exemption amount is pretty much going to guarantee that there's no estate tax when the surviving spouse dies. Now, that is only available for married persons and domestic partners. Okay. So then we get to kind of what everybody thinks estate planning is how do I get this stuff where I want it to go? Okay, so we know that we're going to put property into the trust. Our trustee is going to manage that property, and the property is going to be managed for the benefit of the beneficiaries and ultimately will be distributed to our beneficiaries. Things to think about when you are naming your beneficiaries. So there's different kind of like what we call categories. So a mature person would be somebody who's over the age of 18 and who you know can handle whatever gift you're giving them. This is somebody who, you know, maybe does not have substance abuse problems, is fairly good with money. So that's going to be an outright distribution where we just give them a check. Here's your money. You're in control of it, and we're done. If they're not mature, but they're over the age of 18, we can do a term of years. So we can say, you know, we're going to hold this in trust until you're 30 or 35. You can also do what's called a stair-step distribution, where we say, you know, on my death, you get a third, and you get a third 5 years later, and then you get the remainder 5 years later. So they're very flexible in how we can structure the beneficiaries and how they are receiving these funds. And obviously that's also going to depend on what you're giving them, right? Is it cash? Is it real property? It's going to depend on the type of asset that you think they're going to get. If you want to do some kind of an incentive, you can do that. You know, I'm going to give Anastasia $10,000 if she graduates from college. You know, you can definitely do things like that. If you have any beneficiaries that are disabled, so again, on public benefits, or just are conserved, things like that, we can hold the property in a special needs trust, which can just be built into your revocable trust. There's also this 529A ABLE account that we can designate property to go into. That provides some tax benefits. If you want more information on that, I would say contact me. We're going to be giving any of the attendees here, or frankly, anybody who's referred from FieldHaven, we're going to do a 1-hour consultation for you at no charge. So there's plenty of opportunity for us to talk about, you know, the nitty-gritty on any of these things that we kind of cover today. And then obviously we have our pets, and we want to make sure that we are able to provide for their care and their safety and their well-being after we're gone, because we know that they're probably going to outlive us. So how do we do that? Okay. How do we protect these pets? This is Tripper. This is our COO's dog. So one way that we can do that is FieldHaven's Peace of Mind Guardian Program. So there's a few requirements for this. They do require a minimum bequest or a gift. And Joy, chime in if I've got any of this wrong, but I pulled it right from the website. So it looks like, depending on how old the cat is, there's a different minimum bequest. And that is just because, frankly, older cats cost more money to take care of. And we do not want to burden anybody with taking care of our pet. So that is the minimum. I'm sure that FieldHaven will be happy to accept gifts in excess of this amount.
Absolutely. No problem.
Absolutely. And something to think about is when you're considering, you know, the minimum, do I give the minimum? Do I give more? Well, let's think about it. Does your cat have special needs? You know, how much older than 6 are they? are they used to being alone? Are they used to being with multiple cats? All those kinds of things. You guys know your pets better. And I'm sure that Joy would be happy to kind of talk to you about that and figure out a number that would actually be adequate to provide for them.
I often tell the story of trying to explain, why, because people think that's a lot of money. But there was a number of years ago, a cat was, it was in the trust, and he was, King Tut was 12 years old, and he was a pretty brittle diabetic at the time. And the family, there was $5,000 for him. Well, we thought that should be sufficient. Well, King Tut lived to be about 19 and had many diabetic crises along the way. And I don't know how many more than $5,000 we spent, but his foster mother at one point finally said, you know what, I'm just taking him over. Don't worry. I will take care of the vet bills for the rest of his life. So
yeah,
just like some kitties, they will.
Yeah.
And
just
we
like
want to make
people.
that commitment. We don't want, we want to make that commitment that we can care for that cat for its lifetime or get it into a good home. But if for some reason that cat can't go into a home, and we do have a couple of them here, that we have the resources to care for it for its entire life.
Right. Right. And it's important, we want, our pets are our family, they're our babies, and we don't want to leave them in the lurch. So once basically these bequests are made in your trust. So we add that gift, we direct that, Elsa will go to the FieldHaven Care Program, along with $10,000. Once that is all signed, FieldHaven wants a copy of those documents. There is an enrollment form that you need to fill out with FieldHaven. There's also a questionnaire to complete for each cat, about their personality, health, all that stuff, so that FieldHaven knows all of the history and all of the important details. And then you also want to let your family members, your trustee, the people in your life know that you've appointed FieldHaven as the guardian and that you've enrolled in this care program, so that, your trustee knows to contact FieldHaven and get that whole process started. That should be sufficient to get everything going. I would keep the enrollment form and the questionnaire, I would keep copies of those in with your estate planning documents. That way, when your trustee goes to look at the trust, everything's all in one place. So we can also do an actual pet trust. So instead of just saying, I'm going to give $10,000 to the cat, or, to the guardian for the cat, we can actually hold money in trust for the pet's lifetime. So a couple of things that we consider in a pet trust that we can't really, do in just saying, oh, we're going to give the cat to Stasia with $10,000. So a lot of times we have clients direct that their residence be maintained in the trust until all of their pets have died. And what they do is we set it up where we've appointed a guardian. The guardian lives in the home. The trust pays all of the expenses, or you can say that the guardian's going to pay rent or something like that. Usually, though, they don't. And they are there to take care of your pets. And you can make that as, detailed or not detailed as you want. I mean, I've had people say, he has to go to the vet on the third Tuesday, or, just say that we expect that medical attention be normally maintained. So there's extremes on both sides. You want to think about who's going to be the guardian of your pet. Who's going to live with them, who's going to be able to meet their needs. It's important, it's always important to think about who's going to be your trustee, but it's especially important to think about who's going to be the trustee of the pet trust, because it doesn't have to be the same person as the trustee of your, the general revocable trust. You want somebody who is animal friendly, who understands the needs of your pet and how important that pet was to you. Because you don't want to get into the position where the trustee is, not making distributions to the caretaker when they need things for the pet. We don't want there to be any conflict there. Another thing that we can do in the pet trust is direct that the trustee make random welfare checks on the pet. So it can be unannounced, especially if the guardian is living in the residence that the trust is maintaining. Basically, the trustee will go in every, 3 months or so unannounced to do a welfare check to look at the condition of the home, the condition of the pet, make sure that the litter box is cleaned, there's food, that everything's on the up and up, and that the guardian is doing what they're supposed to be doing. And you can give the trustee the power to take the cat away from the guardian, kick them out of the house, replace the guardian if they're not doing what they need to do. So I would assume that, again, Joy, correct me if I'm wrong, but even if we were to establish a pet trust, we could still use the guardian care program from FieldHaven, and it would just be that there's a more continuing source of funds to provide for that pet's needs.
Yes, actually, we did have someone that did that. But by the time she passed away, all of the relevant, she had livestock, horses, and she had wanted that someone would stay there until all the horses passed away, but they predeceased her, so we never had to do that. But yes, that's very possible.
So it can work, right?
Yes.
Perfect. And then, so there, different ways that we can structure that, right? If we want to, maybe we don't have children that we need to get, provide for, things like that. And it's all going, it's all going to Elsa. And it's all for her. So I do have several clients where, the main trust after they die is the pet trust. And that can certainly work with a private guardian or a guardian care program. So now we're going to do a very brief overview of charitable bequests. So most, animal lovers are charitably inclined. We are just wonderful people that love to make sure that everybody's taken care of. And I think that for animal lovers, animal shelters and rescues and nonprofits that really serve animals are very close to all of our hearts. And so we want to find the best ways that we can to give to those institutions. And we may not be able to do that while we're alive. And so one of the best ways is to provide a gift to a charity such as FieldHaven outright, whether they're caring for your animal or not. And so this could be in addition to the gift for the guardian, or it can be a standalone, maybe you don't even have a pet right then, but we want to make sure that we support this wonderful organization. So we can include a charitable bequest in your will or your trust. All we do is say, after my death, 10% of my estate will go to, and we obviously put the full name in there, but go to FieldHaven. So it can be a percentage, it can be a flat amount, it can be one share, right? It's very flexible. The other option is you can always designate the charity as the beneficiary on any of your retirement or life insurance accounts. You just want to make sure that you get the tax ID from Joy. And you can name them directly, and then basically they will just receive whatever funds are there at your death automatically, and it would not go through your trust. a little bit more complicated, but, and this is just one of the many, many different types of trust that we can do, but it's probably one of the ones that's used most often. And this is called a charitable remainder trust. What it ultimately is an irrevocable trust that you set up during your lifetime. You give property to that trust. The trust will generally then liquidate that property so that it has cash. You receive about usually it's about 5% of that cash annually over your lifetime, and the charity gets whatever's left when you die. Now, this is usually a standalone trust. So you would have your kind of general revocable trust, and then this would be a separate trust. And the goals for a charitable remainder trust are really threefold. Liquidate a highly appreciated asset while avoiding capital gains. Receive tax credit in the year the property is transferred to the charitable remainder trust, and provide a lifetime income stream from this asset. So the way this works, we have some assumptions that we're using. We're going to take the kind of fact pattern where we have a married couple, they're 70 and 65. They have a total estate of $2 million. The asset that we're looking at is appreciated Apple stock. So harken back to that lovely conversation we had about adjusted basis and all that stuff. So we have a tax basis in the Apple stock of $100,000, and it is now worth $500,000. So we're facing, if I were to sell all this Apple stock, I'm facing a capital gain of $400,000. Instead, what I can do, so right now on $500,000, if we're looking at about a 1.5% dividend on that stock, I'm receiving about $7,500 in income every year from having that Apple stock. So here's our market value. We sell, we have a gain of 400,000. The tax that we're going to be paying on that is about 135,000. That leaves us with about $365,000 to invest. If we take 5% of this $365,000, assuming some other numbers of growth and appreciation and all that fun stuff, we can generally expect to get you an income stream of $18,000 a year. At the same time, we've taken an appreciated asset. Actually, I'm going to go back. We've taken this appreciated asset of the Apple stock, we've liquidated it, but because it's in the charitable remainder trust, we actually get a tax deduction for the year that we put the property into the trust. So if I'm doing this in 2021, we do some calculations, and based on that 5% and me getting my $18,000 a year, I'm going to get a tax break this year of $105,000. So that's going to pretty much wipe out any capital gain that I had from any other asset. It's going to allow me to liquidate this, because otherwise it's just stock. I can't do anything with it. I can't, use it to go on a trip or anything. We want to liquidate this. So again, this is really for more of a highly appreciated asset. If you have stock that you've owned for 25 years, this is a great way to do it, because at your death, whatever is left from this money automatically goes to the charitable beneficiary. So this is an advanced planning technique. Again, you're probably going to have so many questions about this, and I could probably talk to you about it for another hour. But you're all welcome to contact me, and we can always sit down and go into more detail about any of these issues. So that is pretty much a very broad overview of estate planning and planning for your pets and for charitably inclined individuals. What I'd like to do now is just open it up to questions. If anybody has questions, I don't know, Joy, if you want to let me know how you want to do that. I don't know if they just
You
want to
can
shout
just,
out. Or...
there's only, because there's not that many of us, you can just take your mic off, or if you don't want to talk, you can put it in the chat. So Nancy, of course, Nancy.
You're gonna love this, Joy.
Uh-oh, what?
You're probably not gonna appreciate this, but my question would be related to you and what your plan is for FieldHaven. Because what I would do might depend on what your plan is to do.
Okay, so that's a really good question, actually, Nancy, because there are a lot of people associate me with FieldHaven. Remember, I'm the founder. I'm currently the executive director. I don't own FieldHaven. While I operate FieldHaven, I do at the direction of a board of directors. So FieldHaven will carry on. I could walk away tomorrow. I could die tomorrow. FieldHaven is still existing.
No, you can't.
Well, I don't want to, but yeah. And I know a lot of people, I always correct people when they say, this is Joy, the owner of FieldHaven. No, I own the property. Preston and I own the property that's here. This one property, the other property in town is owned by, the organization. But no, I will, it absolutely would carry on.
Wonderful.
Okay, good to know.
Yeah, that's a really good question. Thanks for asking it, Nancy.
Sure.
Joy?
Reg.
Yeah, on a parallel to that, the FieldHaven, not the marketplace, is situated on your property. I realize you just said that FieldHaven will continue. Is there a plan for the facility that's on your property?
Well, that's
To
something
continue?
Preston and I are working on.
Okay.
Yes.
And then for a question for Anastasia, you used the terminology of will and trust as ors, will or trust. What's the distinction? What's the difference between a will and a trust? Because I thought a will could be in a trust or part of a trust.
So I think you're thinking about what we would call a testamentary trust, which is a trust that you basically state the terms of in your will, and the trust does not come into existence until your will is probated and, after you're dead. So really the difference between a will and a trust is a will is just a direction that upon your death, assets are to go to certain people. A trust is a little bit more involved. It's technically really just a contract between you and yourself in different capacities. And a trust is an entity. So the trust can actually hold assets and is not subject to the probate procedure that a will is.
So you could have something designated as going to person A in the will, but because the trust says that property is going to person B, it's going to go to person B.
If that property is named in the trust, yes.
Okay.
And generally what we do in our packet, our living trust package, is we include what's called a pour over will. And that is just a will that says, if there was anything that is not in my trust when I die, I direct that it goes to my trust.
Right.
So we use that as kind of a catch-all. But so theoretically, you could have assets, you could have your living trust, and you could have certain assets in that trust and assets that are outside of that trust, and you could direct where the assets outside of the trust go via a will. The issue is that because it's through a will, you're going to have to go through the probate procedure.
Hmm.
So if you're going to do that at that point, you might as well just put everything into the
Put
trust,
everything in, yeah.
totally avoid probate, and you can still meet those goals.
What if you name a beneficiary though?
Say that again.
What if you assign a beneficiary
Like on an IRA or something like that?
that's not in the trust? That
So
doesn't go to probate.
No,
right?
no.
Right.
Beneficiary designations as well as trust or beneficiary designations in a trust are all considered in California what we call non-probate transfers.
Okay.
So the only thing that's going to be subject to probate is assets that are in your name individually that do not have any kind of survivor designation, beneficiary designation, joint owner, none of that.
Okay.
Let's see, private stocks. So yeah, that is, it may be one of those appreciated assets. I've just got a question from Holly in the chat. Private stock. You could absolutely give those to beneficiaries. Again, if it's included in your estate, they're going to get a step up in the tax basis on those stocks as to your date of death. So you're going to give them a huge benefit. And that can go to an individual beneficiary, that can go to a charitable organization, you know, whatever you want to do. If they're highly appreciated and you have a lot of them, and you're looking to liquidate and actually use some of that money, but avoid capital gains, we could probably talk about a charitable remainder trust. But generally, you could treat those stocks just like any other asset. For the fees, so we just have a flat fee structure, basically for the living trust package, which includes the living trust, the pour over will, power of attorney for finance, advanced healthcare directive, a certification of trust, which is just an abstract of your trust agreement for use with third parties like financial institutions and things like that. Your ongoing funding, your routine amendments, and all of your funding work. Let's see, so for married couples, it would be a flat fee of $3,500. For an unmarried person, it's a flat fee of $2,500. But anybody who comes in from FieldHaven, I have directed our office to give a 10% discount to. And so that would be on that total.
Thank you for that, Anastasia. Thank you.
Oh, yeah, I'm very happy to be here. As I looked through the FieldHaven website and learned more about it, I was just more and more juiced.
And then those two kitties were that they
right there.
clinched the deal, huh?
Yeah, and so, okay, Holly has another question. How much money can be given to individuals regardless of taxes to them? So California does not have an inheritance tax, which would be a tax on the money that you receive from a distribution. So really, you know, the sky's the limit. Correct. Yes. The flat fee. So we would take the $250 off. But yes, yeah, so you're going to be able to give an individual as much as you want them to have. You know, things you might want to take consideration of is like, you know, if it's a 19-year-old, do we really want to give them $500,000 and set them loose with it? Probably not. And that's when we get into that whole term of years and all that stuff. Let's see. So Pauline has a, yeah, so basically if you don't have somebody that you really trust and that you would appoint to like be in charge of your assets, there are professional fiduciaries. They do charge an hourly rate, but most of the time, you know, they're only charging for work that they actually do. So if you're just nominating them, it's not like they're going to charge you just to be nominated. And I have some very good fiduciaries who one, I know their billing practices and I know that they're conscientious about that. I know that they do a good job. And two, if you're a client of mine and I know you're working with a fiduciary, I am going to take an active interest in that and periodically check in to make sure that that fiduciary is doing what they're supposed to be doing.
So you trust all these fiduciaries because, people who don't have anybody watching over, they're targeted for being ripped off, whether you're in a nursing home or, that's my biggest worry.
Yeah, absolutely. So I don't trust all of them, but I trust the people whose names I would give you.
Okay, thanks.
Does that make sense?
Yes.
Yeah, so I have a couple of really, really good ones that I've been working with for quite a while on an array of matters, and I have had nothing but, a positive experience. Holly has a question, how much money to put aside for elder care for myself? That's hard to really try to figure out a sum certain. The way that the trust would work is basically all of your assets are for your benefit while you're alive, and it's only after you die that anybody gets a percentage or a share or anything. So ultimately, we really preserve all of your assets for your benefit. If we have to spend it all to take care of you, then so be it. Other than that, I would say estimate on the high side. You never really know. And once you start getting into like in-home care and things like that, it's really expensive. You might also want to look into a long-term care insurance policy.
Question for you, Anastasia. Yeah. So if we bring you on board, we get the trust set up, and you're the administrator of the trust moving forward. But 10 years down the road, your firm goes away in some fashion. Typically in the legal arena, what happens to the administration? Is it inherently transferred to another? Does your firm make an agreement with another firm to take over cases? Do they just go away and the person is sort of left dangling? How do things like that typically work out?
Sure. So right now our firm is structured as a corporation. So similar to what Joy was talking about with FieldHaven is, even if something happens to our principal, Mark Drobny, the firm is still going to be here. If for some reason the firm were to sell or disband, the state bar has very particular rules on how we go about doing that and how we contact clients. Generally, what would happen is most of the time the practice is bought by another attorney or another firm. And what we do is we send out a letter to each and every client stating, that, Drobny Law Offices is disbanding. We've made a deal with X over here who's going to, be buying the practice. And we give you an option. You can either have your file transferred to the new attorney, or we will send your file and all of your original documents and everything to you. And then you can go out and choose your own new attorney.
Gotcha.
I've got a question. How long does it normally take in this? I assume there's probably more than one visit with your company. How long is that process, that day, the first day and then subsequent?
So the first day, it's probably about an hour. We send you some questionnaires to fill out that we ask you to return either ahead of time or at the meeting. And that's all your financial information and all your, kind of jostling you to think about who you would name as a trustee and all that stuff. It usually takes about an hour, or, it's as long as it takes, really. But I would say usually an hour, hour and a half to get enough information to get drafts going. We will then prepare your drafts for you within a couple of days. We get those out to you, and then you can, your package price includes up to 2 meetings with the attorney to review your drafts, ask questions, make changes, all of that. After one or both of those meetings, you get another meeting where you actually come in and sign your documents. And that, the time, you know, can vary depending on if you still have remaining questions, how much of a review we go through. So ultimately, you know, we want to make sure that you're comfortable signing your documents. So while, you know, I would say you get the first meeting, 2 review meetings, and you're signing. So a total of roughly 4.
Where are you guys located?
We are in Natomas, in Sacramento, the corner of Truxell and Arena. But you don't have to come in. We do Zoom meetings, we do telephone meetings. You can sign, you know, I can send you your documents and you can get them signed at home or whatever, or you can come in here. We are doing in-person appointments. We have the plastic dividers. We've all got our vaccine shots. We wear face masks. You know, we're taking all the precautions that we need to so that we can get people in, because unfortunately the legal profession has not caught up with the rest of the world, and we still have to have wet signatures on things, and DocuSign has not reached us yet. And Holly, yes. So, oh yeah, ongoing email questions, absolutely. So we're not going to see any kind of an hourly charge. I don't care if it's while we're doing your drafts or if it's a year later. If you have a quick question, or, you know, can I do this, or how does this work? We don't charge you for that. You know, if you want to sit down and go over your trust for another hour in a couple of years, we'll charge you for our time there. But generally, you know, if you shoot me a quick email, or you need a copy of something, or you just have a question about, you know, what's the name of my trust? We will respond to those. Absolutely. We consider this a continuing relationship. So you're not done when we give you your documents. You are kind of stuck with us, whether you like it or not. So
Dale asked you another question, Anastasia, that's above.
Yes. So okay. And really quick. So Holly, a yearly update is included, but so the way we do them is we send you out a letter to remind you once a year, yeah. And the routine amendments, if you send them in by writing, so email or a letter, we will just grab your file, do your changes, send them out to you. You know, you send them back when you've got them signed, and then we're done. We do charge if, you know, you want to sit down with an attorney and ask multiple questions about, you know, should I change this, or how will this affect this? That would be billed at an hourly rate, because we don't consider it a routine amendment, but we are fairly liberal about what's routine. So generally, if you're not requiring a sit-down meeting with an attorney to really go in depth about certain issues or how various changes will be affected, it's going to be routine, and there won't be any charge. And also, you'll know, like if you call to set a meeting 5 years down the road and said, you know, I think I need an in-person meeting, we will let you know right then whether that will be charged. And how will we know the seminar? So I'm going to send Joy just a really one-page kind of an evaluation sheet. And on that, there's boxes that you can check to say, yes, I want my free consult, and here's my information. And if you'll just email that back to me, we can get you set up with a consult or whatever we need to do. And yes, we can cover digital assets in a trust. It's actually, are you doing like cryptocurrency, or are we just thinking kind of general? Okay. Yeah, cryptocurrency is fun to figure out. But for the general assets, absolutely, we can cover that in your trust. Your power of attorney will also include the authority for your power of attorney, your agent, to access your not only digital assets, but like your digital profiles. So, you know, Facebook and all that social media stuff.
Fabulous.
Yeah.
Perfect. That's what Dale said. Perfect.
Did you give us your contact information?
No, well, she'll send that in the survey, right, Anastasia?
It's on the oh my God, I'm blanking. The evaluation sheet.
Okay.
My contact is on there. So if I'll send that to Joy, if you don't mind blasting that out to everybody.
I will. Yes.
And then just while I'm here, I'm going to put my email. I just put my email in the chat. So just, you know, and I don't mind. I frankly enjoy being a resource. So if you do have, you know, a quick question or, you know, like the things that the questions you've been asking today, feel free to shoot me an email. You know, I'm happy to, like I said, be a resource, and it's kind of our way of giving back.
Thank you. Thank you. That's like what we do, Nancy, right?
Right.
And then the healthcare directive, they can be tricky. What you want to do is just, you know, and I don't know why they said they were tricky. They're a much broader document than like a POLST or a DNR. So we really just want to make sure that you've thought about your end of life choices. You know, do you want palliative care, that kind of thing? And we can always chat about that a little bit. I can only give so much guidance because those are really personal decisions. But we can always talk about it. Drobny in San Francisco, we very well might be. I'm not sure, but it could be. And then let's see, if we set up a trust and move out of state, your trust is still good. Generally, your trust will say that it is organized and operated under the laws of California. So then even if you move to Nebraska, when you die, the trust will be administered pursuant to California law. But you can, a California trust can hold property in another state. You know, so if you buy a house in Nebraska, we can still put that into your trust. You do not need to get a new estate planning package.
Joy, does everybody know how we came across this firm and tonight?
Yeah, I can share that. It's just, you know, it's just networking. One of our very good and longtime donors, Mark Glickman, I'm not sure how he connected with you, Anastasia, but it was through, I think this is Sacramento SPCA, I believe. I believe that's,
so.
Yeah, there was
kind of like a,
yeah, there was a jump, a hop, there was 3 or 4 degrees of separation, but yes.
But I'm very glad we did. Like I said, the more I looked into FieldHaven and as I talked to you guys, this is an awesome organization.
Thank you. We're very proud of it.
I bet you should be. And I am so pleased that you allowed me to be part of it.
Well, thank you.
Let's see, one misses putting even a tiny asset. So not necessarily. Let's say that we pretty much funded our trust, but we missed something. Often what happens is the house isn't in the trust when someone dies because they refied it and they made them take it out of the house and then take it out of the trust and then they forgot to put it back in. There's a procedure that we can use under the probate code where we can ask the court to declare an asset, a property of the trust, even though it wasn't titled in the name of the trust. To do that, the pour over will helps us show the court that you intended for all of your property to be part of the trust, so we can get it in that way. The other thing is, and this is exactly why we do that pour over will. The other way we can do is through the small estate affidavit procedure, which is where if the assets outside of the trust are under that $166,250 limit, we can use a small estate affidavit through the pour over will to haul those assets into the trust after the death. So there are ways that we can avoid probating even if an asset is left out of the trust. Oh my gosh.
Joy was there for months.
Oh, I just read the comment. I was like, what happened?
Yeah.
Oh, thank you, Cindy. Yeah, I lived in paradise after the fire for about 7 months, and
Months and months and months.
it was an
After a lot
adventure.
of other people. Huh?
It was an adventure of a lifetime.
I bet.
And I helped out at the Marysville shelter for several months.
Oh,
Thank you, Cindy. Yes, that was
Yeah.
over 700 cats we rescued from the fire, Anastasia.
oh my gosh, that's wonderful.
Yeah, I was where I
After a
was
lot
2
of
years ago.
people-
Right now, that's where I was,
Yeah.
living in an
After a lot
RV.
of other,
Oh, how
after a lot of other
that was.
organizations abandoned ship,
Yeah. Gosh,
Yeah.
I can only imagine.
a lot of others left, took the money and ran,
Yeah.
but we won't go into that.
Yeah, we're not going to that now. Let's not go into that. Let's keep this happy. We
Yes.
saved lots of kitties, and we had a lot of support, and a lot of people helped us, and I met some incredible people there.
Holly, I just put a link into the chat about that $166,250. And then if you have further questions, feel free to email me. Sometimes it just takes maybe an example or something to kind of put it in context. It's a weird, nice round number that some lawyer made up.
Yeah, really, that's an odd number.
It used to be 150. It was 150 for like forever. And then they just changed it last year and we were like, where did this come from?
Somebody just picked a number. That's crazy.
Definitely. I'm sure that you guys have more questions. I'm happy to answer them. Feel free to reach out. Like I said, I'll be getting Joy the my God, why can't I think of this name? The
Evaluation.
Thank you. The evaluation sheet. So you'll all be getting those. If you wouldn't mind, take 5 minutes, rate me, give me a grade on the presentation. Let me know how we're doing on that end. And then just provide your info and we'll get you set up.
Fabulous. Thank you, Anastasia. Thank you very much, and thank you everybody for joining us. I did record this, so if you're somebody that you think you want to show or hear the same information, let me know and we'll get them the recording, and tell them there are cute kittens that are part of part of the presentation, and some
Right.
really cute cat pictures in your presentation, Anastasia.
When do I ever get to use those?
Yeah,
In my life, right?
of course.
Yeah. So, I had
Set
fun.
up an appointment with Anastasia and you get a free kitten.
Yeah, that could be a deterrent. All right, thank you so much, everyone. Thank you, Anastasia.
Thank you, Anastasia, and thank you, Joy.
Have a wonderful evening.
Seriously, bye-bye, everyone.